All judicial office holders are required to conduct themselves appropriately, free from bias, and to treat people fairly and equally.
All judicial office holders take the oath or affirmation when they are sworn in to do right by all manner of people without fear, favour, affection or ill will.
It's obviously important that judges behave properly and fairly when they are sitting as judges in court. But it's also really important that when we're out of court, we still behave properly. And that applies as much to fee-paid judges like me as it does to salaried judges. And so what does that mean to behave properly? Well, in lots of situations, it's very obvious, but there are situations where the answer is rather more nuanced. We are lucky to be helped by a guide called the Guide to Judicial Conduct, which is available to us all online. And rather than setting out a list of do's and don'ts, what that guide does is sets out a list of principles, and it makes it very clear that it's up to the individual judge to think about and interpret those principles and apply them to particular situations.
New judicial office holders, when they go through the induction process, will, as part of that process, receive training on ethics. They will discuss scenarios, ethical scenarios, both inside and outside the courtroom, and the appropriate way to deal with them.
Ethics, well, it's your core principles, they're your moral values, and they guide every decision you make. And it's not just the decisions you make in court. For us, it's everything we do out of court as well, because we're accountable. And we're accountable to the highest standards, and that's what the public are entitled to expect of us.
As judges, we must be independent and impartial. Defendants and litigants in person have the right to appear before a judge who is free from bias. Courts have long recognised that justice must not only be done, but seen to be done. This means that a decision made by a judge must be and must appear to be free from bias.
Equality and fairness is very much at the heart of what we do and what we must do as judges. And the Judicial College has published a book called the Equal Treatment Bench Book. It's designed to ensure that judges can fully understand diversity in all its forms and guises and be able to deal properly and fairly with people.
Also says that he would like to be called Autumn Leaves. Bit of a silly name.
Oh, I don't know. What's in a name? But before you show people in, Brian, I think I'm just going to take 10 minutes to look up on my iPad on the Equal Treatment Bench Book about transgender people. So just give me a moment, please, to look at that.
Of course.
Okay, thank you.
And the Equal Treatment Bench Book is an online resource. It is not a paper publication. It is an online resource which allows ease of movement around from one section to another, cross-referencing very easily. It allows the judge to react quickly and easily as a situation arises in the court or tribunal room, allowing the judge to find the necessary information, for instance, on a particular disability or a health problem, or on a particular naming issue, or some such matter that is dealt with in the guide. It includes, for instance, making reasonable adjustments for those who have disabilities of some sort, and it's also designed to ensure that the young and the vulnerable are able to properly and effectively participate in the court and tribunal hearings.
Our guidance is distilled from the Bangalore Principles of Judicial Conduct. And those were principles which came out of an international conference where judges from a number of different countries met in 1988 in Bangalore. And they were focused on how judges could help to promote international human rights. And they were really trying to draw out the central core principles of good judging, which would apply to judges at any level, in any jurisdiction, and in any country. And from that work came these 6 principles, the 6 Bangalore Principles, which apply to all judging in our country as well.